Now, if you're going to move on to foreign divorce, now if Nelson and Eleanor were to divorce, and just for clarity, their marriage is in the U.S. Now, so the divorce will be in the U.S. So maybe for this, based on which U.S. court will exercise jurisdiction in divorce proceeding. I mean, possibly John can answer this, and whether U.S. courts has the power to vary matrimonial property rights, and is U.S. Pre or post nuptial agreement legally valid, versus to Philippines assets. So John, can we have you answer this couple of
Sure,
questions?
sure. Thanks, Mary. So again, with divorce law, it's based on a state-by-state implementation, and divorce courts operate on a state-by-state basis, not federal. So we'd be looking to determine which state is going to claim jurisdiction over the divorce proceedings. Each state tends to have a domicile or residence approach to this, but they vary widely how long you have to be there to establish that. It can be as short as 2 weeks in some jurisdictions, as long as 6 months or longer in other jurisdictions. There's a general tendency in the US to want to avoid being seen as a divorce mill where someone just tries to claim residency in that to take advantage of the rules in that jurisdiction. So we'd analyze where Nelson and Eleanor were. If this is often the case with dual citizens or expatriates, if they're not living in the US in a particular state, the tendency, the US from a citizenship federal perspective, you're always domiciled if you're a US citizen in the US, regardless of where you're living. The states don't operate on that exact same definition. Most likely outcome is we look at the last place the last state they lived in the US to try to grab a jurisdiction for that if they're living outside when the divorce starts. On variance, the US does have the common law variance power within its court system, although it tends to not be used to the extent it is under the UK system. I know it's much more prominent in the UK system, not in the US. If you're going to see a challenge to a trust or a prenuptial agreement or any type of property assignment, sham or fraud is going to be your primary or first challenge to it. And then that leads nicely into the last question there about pre and post nuptial agreements. The US tends to have 4, I'd say they're guidelines like Joshua mentioned, but they're a little stronger than that. They're almost absolutes, not codified maybe statutorily in every state, but the 4 things to really look out for both in pre and post nuptial agreements. I guess it's 3 for post, you'll see in a second. Each party has to have independent counsel. It's really almost absolute. They each have to be represented. There has to be full forthrightness. So each side needs to come and say, this is what I have, this is what I'm bringing into this, or what I have right now. If you hide an asset from that discussion, it really is going to avoid the entire discussion and not make it be honored afterwards. You should avoid any custody or duty elements. So don't talk about who gets kids or what happens with the kids, or I have a responsibility to take care of this aspect of the marriage, like the finances or cooking and cleaning or whatever. Those things are not valid in a pre and post nuptial agreement arrangement. And then lastly, and this one's only for the prenuptial, is rule of thumb, about 6 weeks out before the marriage day. Do not wait until you're rushing to the church to get married. That will be seen as kind of an undue influence on the party that's going to be attempting to challenge it later.
All right. Okay.
So for the next slide, so in this case for Nelson, John, can the U.S. court seek to vary the terms of the Philippines trust in this case?
Yeah, like I mentioned earlier, variance is possible under the common law system in the U.S., just not as it doesn't occur as much. It's not a tool that is used as much in the U.S. as it is in the UK system, as many practitioners will be familiar with, and Zach deals with regularly.
Mm. And Joshua, in your view, will the Philippine court enforce a U.S. court order to vary a Philippine trust?
Yes, that is a possible scenario, Mary. In the Philippines, Philippine courts can recognize and enforce foreign judgments. So if a party is successful in in securing a U.S. court decision or order which varies the Philippine trust based on whatever applicable law there was in the US, then it can be enforced here, but again, subject to the proceedings before the court, for the court to validate the decision that was issued by the foreign court.
Okay. In this case, for the U.S. court, would the U.S. court seek to divide the shares in the Philippine trading company, which I think there are some restrictions?
Yeah, I would say they could. Probably reserved for only the most egregious examples where they're trying to right an obvious wrong under the local definitions or treatment. And then I suspect the next question will ping pong back to Joshua. Would that be respected?
Yes, correct. Yeah, so for Joshua, I think we will go back to the Philippine court if it will enforce the U.S. order to divide the ownership of the Philippine companies.
Yes, so again, it would be similar to the first scenario. A Philippine court will be open to recognizing and enforcing a U.S. court order or decree, subject, however, to the proper proceedings for the interested party to prove that the decree or the order secured from a foreign court meets certain standards for it to be recognized and enforced in the Philippines.
Okay. Now, whether the U.S. court can seek to vary terms of Singapore Hong Kong Trust, and whether Singapore and Hong Kong law provide relevant firewall protections. I think, Zach, what's your comments on these two questions?
Yeah, I think probably John will say that the US court would probably look at the case of having some authority to vary the trust, probably not going to be as active as the UK courts have tried to be in the past on these things. From a firewall protection, no, we don't have in Singapore and Hong Kong specific firewall protections, sort of modernized firewall protections that you would find in some of the other international financial centers. Singapore is very much aligned with the sort of UK, New Zealand, Australian sort of approach of being sort of a jurisdiction that doesn't have all of the array of protections that are springing up. So what would happen in Singapore, it'd be a very unusual circumstance because generally you're looking at money judgments being recognized. In this case, you're looking at a variation order. So I think it would be a matter of comity between the jurisdictions as to whether or not a Singapore or Hong Kong court would want to help and assist a US court in its matrimonial sort of regime environment and its enforcement in seeking to vary a trust. But there's no frontline protections in either jurisdiction dealing with what they call personal relationship protections, and one of which is the marriage or the consequences of a dissolution of marriage. So no firewall, but you would still have to get through on the basis that there's not going to be an automatic recognition of a money judgment order here because there's no money involved as such. It's a variation request. But yeah, it would be an area that would have to be falling on Singapore courts and Hong Kong courts, looking at the US and seeking to help them out in this instance. So the more egregious the status of the divorce, if Nelson is hiding assets and being quite difficult in the US proceedings, let's say, then generally common law courts will look unfavorably at a divorcing spouse trying to do that. And that's been the case in some of the Jersey judgments, that they don't want to help someone who's actively trying to frustrate another jurisdiction's court's attempt to, reconcile the parties and make a clean break.